Good day, everyone. Welcome to Lawyer Up by NDV Law. I'm Attorney Nikki de Vega, the managing partner of Nicolas and de Vega Law Offices. Today, I will clarify certain mandatory requirements for FDA registration in the Philippines. Do you need to employ a pharmacist even if your company is selling cosmetic products or medical devices as a requirement for registration with the Food and Drug Administration or FDA of the Philippines, or in applying for an LTO with the FDA? To answer this question, we need to understand the legal requirements governing registration with the FDA, particularly in securing a license to operate or LTO. It is quite understandable if the application for registration with the FDA pertains to a drug or a pharmaceutical product, but the presence of a pharmacist is obviously essential for the company's operations. However, the requirement seems far-fetched if the applicant for registration is applying for an LTO in relation to a cosmetic product, a medical device, or even a food product. The old rule was that a permanent and a full-time pharmacist was necessary in order for a company to secure an LTO. Thus, even a cosmetic company must have a full-time pharmacist under its employment. This finds basis under Section 23 of Republic Act No. 5921, otherwise known as an act regulating the practice of pharmacy, which defines the practice of pharmacy. According to this law, the practice of pharmacy includes dealing with cosmetic products. Consequently, the FDA mandated almost the same requirement for cosmetic and drug companies, which includes, among others, the presence of a duly licensed pharmacist who has attended an FDA-accredited seminar on licensing. Previously, the pharmacist played a vital role in the company's applications with the FDA. It must be emphasized that it is the pharmacist who actually signs the petition for application of an LTO with the FDA. Furthermore, the pharmacist also signs a joint affidavit of undertaking to be filed with the FDA. These requirements were mandatory with the FDA. The pharmacist, previously required by the FDA, must be engaged to render services full-time to the company, or briefly, a full-time employee, since the FDA requires that the operations of the company be under the immediate and personal supervision of the said pharmacist during business hours of the company. Such obligation is also spelled out in the petition and joint affidavit to be submitted with the FDA. In addition, if the company is to engage into activities, for example, the distribution of cosmetics and also the importation of food supplements, two pharmacists may be required by the FDA for the company. This will be necessitated by the fact that the company must apply for an LTO for two activities, namely as importer and distributor. This is in view of the fact that pursuant to Administrative Order No. 56, Series of 1989, the LTO must be applied for each category and one pharmacist must be employed for each classified category. Now, let's go to the new rule. I bet you guys are excited. Well, under Administrative Order No. 2016-003, the FDA relaxed this requirement for some industries. Consequently, the requirement of hiring a full-time pharmacist is required only for drug companies or drug establishments. With this administrative order, the FDA now refers to a qualified person. Thus, for drug establishments such as pharmaceutical companies, drugstores, and establishments dispensing medicine, the FDA still requires the presence of a full-time pharmacist to supervise the operation of the establishment. However, for cosmetic companies and other businesses engaged in the sale of medical devices like medical device establishments, the FDA requires either the presence of a full-time pharmacist or other qualified professional The other qualified professional required by the FDA refers to a professional who is licensed by the Professional Regulation Commission or the PRC, such as persons who are engaged in the allied science professions of, let's say, dentistry, dental technology, medical technology, midwifery, nursing, nutrition, dietetics, optometry, physical or occupational therapy, psychology, medicine, and the like. In addition to a PRC-issued ID, the FDA requires the other qualified professional to attend the seminar for qualified persons in industry regulatory affairs or KIPIRA conducted by the FDA or its accredited counterparts. Moreover, for food establishments such as those selling food supplements, the FDA now requires, in lieu of a pharmacist or other qualified professional, the presence of a full-time regulatory officer who does not need to be either a pharmacist or a PRC licensed professional. Of course, the FDA was not remiss when it relaxed the rules. The FDA requires the regulatory officer to have attended the appropriate licensing seminar or seminars of GMP, good manufacturing processes, hazard analysis, and critical control points or HACCP, or FDA conducted accredited food safety seminars. The FDA even relaxed the requirement further by allowing the submission of a promissory letter with a commitment to attend the required seminar in case the regulatory officer or other qualified person under the cosmetic, medical device, or food establishment's employ has not yet attended one. I hope that I was able to shed some light on the FDA mandatory requirements. If you like this video, kindly hit that subscribe button. You can also visit our Facebook page and our website, ndvlaw.com, for a wealth of legal resources. This is Attorney Nikki de Vega of Lawyer Up by NDV Law, signing off.